Are there if you ever need. Again, feel free to take a break as you please. Our next session is Blockchain Compliance Today, the Q&A. In the spirit of the CLB Festival has been quite interactive. We decided that rather than have another typical panel, we just open up with self-introductions and then just go launch into Q&A from the start, so you can ask all your questions. Usual disclaimers, not legal advice, but consider it personal opinions, guidance, things like that to help everyone in the space, whether you're a lawyer working at a startup that might have questions about what's going on today and so forth. There's a lot to be covered. So let's actually have our panelists take a seat on the couch. Always nice. Therapy. Right. Then Jonathan as well. Yeah, if you like. I think we can, that's perfect. And then Jonathan maybe can sit down here. I'll take a seat here. We wanted to have a diverse kind of spread of disparate, but I would say interconnected slices of the blockchain space. So we have obviously academia represented in Jonathan. We have our expert legal practitioners from Orrick, very much an active firm in the space, as you probably know, and also sponsors of our festival. So thank you and welcome. And we also have LeFever, who is at LGO Group, and she'll explain what that's all about. So self-introductions, Jonathan, if you'd like, unless you feel like.
Yeah, I teach technology law, telecom law, startup law at Brooklyn Law School. And one interesting thing I've discovered over the past year or so is last year, all of my students were talking blockchain all the time. This year, I don't know, I have a couple theories on what happened, but no one really is talking blockchain this year. My students, everyone wanted to learn blockchain last year. No one cares about learning blockchain this year with a couple exceptions. I think what happened was the ICO meltdown and all the fraudulent transactions there, and everyone got a little bit panicky. But isn't that the perfect time for lawyers to get involved? If there aren't great opportunities now for lawyers in the blockchain space because of fraudulent ICOs, I don't know what is. I think we've all stepped back as an industry and we've got to rethink what's going on. Last year, the students and I built a prototype for a global blockchain policy wiki. The goal was to create something that the legal hackers community around the world could use to self-populate the laws of the respective countries and regions so that we could all share information across the globe and figure out where the havens and pariah states might be for different blockchain technologies. I would love to use this community again to relaunch that, something like that. A vehicle, essentially a crowdsourced, self-populatable vehicle for lawyers, mostly lawyers and policymakers, to understand the global framework. That's sort of what I want to throw out there. Things have changed a lot in recent past few months about what's going on around the world and among the states as far as blockchain rules and compliance and crypto compliance issues are concerned. And that's probably where this discussion is going to go to some extent, I think.
Does this work? Yeah. Hi, I'm Dan Nathan. I'm a member of the Gilded Legal Society. There's a separation here. I hope it's not symbolic. Hopefully we're on the same. Hopefully we're on the same side of the issues. I hate to hear that where lawyers come in is to clean up the messes that are made. Being a member of a big firm, yeah, we make a lot of our, a lot of what we do comes down to economics and dollars and cents, and we're not quite vultures, but we make a lot of our money off of things that go wrong. And that's my career is, most of my career is with government, being one of the ones who makes things go wrong. I did enforcement work at the SEC, the CFTC, and FINRA, which regulates broker-dealers. So although I left 6 years ago, it was really before blockchain was a thing. So I went into private practice where I represent everybody who I used to go after in enforcement, and then have come into the blockchain world, which is a long prelude to saying, yeah, a lot of my work is cleaning things up, but hopefully more and more of my work is helping set things up in the right way. It takes a thief to catch a thief, and it also takes somebody who knows how to prosecute and bring cases to figure out how to make things work right. So I'm a member of our firm, and our firm is known for being highly innovative and being heavily into lots of types of new tech, also AI, also driverless vehicles. We won't talk about that today. And heavily into blockchain. And we are fully into every stage of the blockchain process so that I don't, by the way, I do lots of other work too, but I'm not sitting at my desk waiting for something to go wrong. If something goes wrong, we want to be involved. And, being just 6 years in big law, I've managed to convince myself that everything I do is actually okay. It's all right. And 8 years ago, you wouldn't have heard me saying this. And let me just run down very quickly what big firms do, what big law and other law firms do in this area. And one of my former colleagues from another big law firm, Kevin Sadecki, who's with Schiff Hardin, can also fill in some. What we do in our firm in the blockchain area is basically 4 things. We help raise capital through for blockchain companies, through traditional means, through ICOs, through STOs, through SAFs. We help come to market. We help contract. It's called technology contracting. We help the product companies contract with others, basically. It's what lawyers traditionally do. It's called technology contracting, and we help put things in place, including contracts with all of your users, terms of service agreements, all of that. We do that. We also help entities who are under regulation by any regulator who are within jurisdiction come into compliance. And that's much more of what I do personally, because that's what draws in the background. So, and we'll get into, I assume, from Q's and A's, what areas there are, but there, until we get into that modern world, the new world everybody's talking about, where, you don't have to worry about a 60-year-old partner, hewing to traditional means, unfortunately, those are the systems we have to deal with. Those are the legal systems, that's there, and as much as we'd like to avoid it, and as much as cryptocurrency and the blockchain has been established to get around that, it's still there, and you can count on the regulators being 5 or 10 years behind technological innovation. So that's what we do. And then the last part is the vulture part. The last part of what we do is, again, when people get sued, investigated, sued by the government, prosecuted, we're there to try to help them out of it. And again, I feel good about it because in most cases, literally most cases, it's based on the government's misunderstanding of the area. And in most other cases, it's based on an entrepreneur's incomplete understanding of what's required. In very few cases is it based on somebody who wants to go out and rip people off. It just isn't. So again, I feel very good about being able to operate in that world. Let me introduce, and hopefully this should be Q&A, and hopefully I threw out enough there to whet your appetites and we may be calling on some of you to help pitch in, because we're gonna stay within our lanes. We know some stuff we don't know. So let me pass it on to my colleague, George Pesok.
All right, sir. Oh, perfect. Well, I'll take both. All right. Hi, my name is George Pesok. I'm also at Orrick. I'm a managing associate there. Dan did a great job at introducing kind of what as a big law firm, how we view our ability to assist companies in the space, which is, I personally have a bit of a internal battle going, because I'm a believer in the space. I think it's going to bring about a lot of change. However, as a white-collar securities litigation attorney, the government's rules don't change as fast, right? So it's how do you continue to promote the development in the space within the construct that it has to fit within, and a lot of times it just doesn't. So a lot of these companies have to take the risk, go out there, make a huge enough change so that the government has to accept who they are, what they're doing, and change in that way. It usually doesn't happen, but when it does happen, it's a huge victory. We have seen a little bit of movement from the government's point. For example, Hinman's statement that you can have something that's issued as a security and then converts into a non-security. And then Clayton kind of jumped on and said and blessed that by saying that he agrees with that kind of analysis.
Very recent, right?
Very recently, right?
Yeah.
That's huge, right? The SEC does not move much on their rules. So the fact that they said that, there's some light at the end of the tunnel. However, that in itself raises a huge amount of legal questions, right? So, and we can get into those too, but it's not a complete victory. Now you have other regulators to worry about once you're no longer a security, so you have to think about that as well. So I think that's enough for me. So if you have, we're here to answer any questions that we can.
So first off, I just want to say thank you to Steve for organizing this and inviting me to be a part of this panel. I feel honored to be with this esteemed panel who probably knows a lot more, has been in the space longer than I have, but anyways, my name is LeFever. I am a compliance and operations associate at LGO Markets, which is a part of a larger company, LGO Group.
So, okay, great.
Anyway, so a couple years ago, I was one of those students that Jonathan was describing. I had the honor of taking a class by Professor Shadab. Some of you guys might know him. I know he was involved in organizing this last year. So I had a class, he mentioned smart contracts and blockchain. I was like, oh, this is really interesting. I should probably write my final paper on this. And so I did that, and then that led to other papers, law review articles, etc. And I kind of saw when I was graduating from law school how it plays into securities law and securities litigation. And at the time, I was at a law firm who did securities litigation, so I was, talking to the managing partner. I was like, this is something we need to be paying attention to. So at that point in my life, I was either going to continue at a law firm and maybe end up, if I was lucky, like one of you guys. But then I had the opportunity to meet the chief compliance officer at LGO Markets. And I was like, well, that'd be, really cool to take this other route and sort of go in-house and actually be a part of, what I view as like on the grounds, compliance and regulatory and legal work. So I guess we'll see. I mean, I learn a lot every day, and who knows, what could happen. I could stay there, go somewhere else. Anyways, what attracted me to the company was I see this, cryptocurrency exchange market. There's hacks every day. I think there's a new hack today. And they're, like the New York Attorney General's report, they're acting with all these conflicts of interest, manipulation, and LGO Markets, we aim to sort of do what is capable with this technology, that is, bring fairness, security, and transparency to a market where, it boasts about being like, oh, come join this decentralized financial ecosystem, when actually you're using a centralized exchange that might actually be, worse off as far as safety of your assets. But this company, I think, has taken, blockchain for one of its purest uses that I can see. We have an anti-front-running module built into our platform. We don't hold client assets. So it's also interesting from a regulatory perspective with our, sort of unique infrastructure. How does that fit into, traditional laws and, other centralized exchanges that are going the, money transmitter route, et cetera. So anyways, I welcome your questions, and I hope I can answer them.
Great, thank you for the introductions. Just to quickly reintroduce myself, Stephen Nam, Managing Editor of the Stanford Journal Blockchain Law and Policy. We are basically the sole blockchain-focused academic journal at Stanford currently, and we're all about being a disinterested, neutral, hopefully reputable platform to advance discourse and really kind of have this layer of academic literature that others can build upon, whether that's practitioners, academia, and so forth. So happy to be here. We can begin the Q&A. I do have some very general starter questions that might help to kick off, unless someone wants to go first. These do not need to be answered in any particular order. Also, of course, the panelists can choose to kind of, bypass certain questions if it's sensitive. But let's always try to be respectful. My question, so just again, don't need to be answered in any particular order. You can bowl over them as you like. For our Professor Askin, I was curious, so 2019 is obviously very different from 2017 and also 2018, right? The space is evolving very rapidly. We have seen a lot of, I would say, regulatory arbitrage across different jurisdictions, and even between, amongst the several federal agencies in the US that have more or less been tasked with oversight of the space. My question for you, Jonathan, is, do you feel like, as of now, today, the SEC, its general role, like most other federal agencies, of kind of having to balance protection of consumers with technological innovation and so forth, do you feel like you're comfortable with the pace or the approach that the US government has been taking? If yes, why? If not, why not? And that's for you. Quickly for Daniel and George, also, just in terms of you being on the ground with a lot of these startups, these enterprises that are dealing with regulatory issues, compliance issues, what do you think, again, today, 2019, are some best practices that a lot of startup founders and staff might not really be cognizant of? Because as you know, a lot of these startups don't have upfront legal help or in-house counsel that you might want to kind of warn them of, caveats, et cetera, steer them towards, et cetera. And Lisa, for you, you're very much in the space with a company that's active again in the spirit of decentralization. What are some, I believe, am I correct, there was an ICO, is that LGO? There was an ICO recently,
LGO
right?
Group, yeah, they did
Yes.
an ICO under their French entity.
Okay, oh, okay, interesting, okay, got it. That was very recent, right? February or so? Never mind, okay. So just curious, like what I guess regulatory compliance issues you are facing in general on a weekly basis, and perhaps what you foresee. So again, doesn't have to be particular order.
Well, I'll start. I think we are beset with regulatory uncertainty beyond anything we've ever seen in the history of humanity, and that is devastating for business certitude and consumer certitude. So here are the big problems. We have way too many entities, authorities that are regulating different aspects in different ways. You've got local governments, state governments, federal governments, international, foreign governments, international treaties, and no one knows what the rules of the road are. I'm an old telecom lawyer, and the one thing I learned in 20 years of telecom is that you can never be sure what the next administration or the next jurisdiction is going to do to your venture, so you've got to prepare for all contingencies. That's a terrible way to run a business. For those of you who followed any of the net neutrality telecom battles, one year you got net neutrality rules and you know what the rules of the road are, and the next year you don't. And it depends on where you are in the world. That's why we started last year this effort to create a global policy wiki, so we can get some understanding of what the map looks like globally. So the things I like now are the regulatory laboratories. How many of you are following what's going on in Wyoming, for instance? Wyoming is trying to become a haven for crypto and blockchain ventures. Are they going to succeed in a world in at least a country with federal supremacy? I don't know. But they're trying to, Vermont now has at least a rudimentary, we heard about this last night, a rudimentary statute allowing for LLC formation on the blockchain. It's a baby step into something. Delaware's trying. If you think about what's going on in Wyoming, this is not the first time Wyoming has tried to disrupt the business world with a new technology or a new product. I think it was 30 years ago, 40 years ago now, Wyoming was the first state, I think, to pass an LLC statute. It was an effort to turn Wyoming into the Delaware of flexible corporations, essentially. Delaware owned the C Corp. Could Wyoming create this new sort of corporation that would be more flexible than a traditional C Corp? Well, Wyoming succeeded, and it succeeded like gangbusters, so much so that every other state adopted the tool. So I think this is what we're going to see in the crypto space. We're going to see these state or foreign state laboratories, and people are going to flock to them. We'll see a lot of successes and failures. I think to some extent the federal government might be right to hang back a little bit and see what Estonia is going to succeed or not succeed, and what Wyoming might succeed or not succeed at an interstate level. But I have no great hopes that our federal government, especially if it fluctuates between administrations, Republican guards, Democratic guards, CFTC versus SEC versus Treasury, what have you, I don't think we're going to see much certitude from the feds in this process. So we've got to be out there looking for other havens in our own laboratories where we can actually prove out the concepts.
Yeah, it's sort of the only area where Wyoming and Estonia are used in the same sentence. Right? Otherwise, they, I think, have almost nothing in common, although I don't know what the terrain is like in Estonia. Is it mountainous, and do they ride the range? So yeah, the comment about laboratories is great. It's fascinating. Look, 10 years from now, we'll look back and see the kind of gradual focusing and unblurring of this whole area. Right now, it's, on both the government and the entrepreneurial side, things are blurred and developing in different fits and starts. I guess the one thing to add to Jonathan's answer about the differences between 2017 and 19, I think 2017, in the very heady days of saying, hey, let's use the blockchain for everything, you had people raising money for blockchain applications using, ICOs in the blockchain. We're seeing a lot less of that now. We're seeing, yes, you have a practical application and you need funding. Let's go back to what's being done traditionally. We know how to do it. We've done it. why make it more complicated with having these sort of hybrid tokens that George referred to, where it starts out as something that's security and then becomes not a security? At what point does it stop being one? Can you draw a line there? At what point are you subject to SEC versus CFTC jurisdiction? At what point are you vulnerable to certain cause of action versus others? And we can get more into that, but that's again just to supplement these comments. We're still in year one of a 10 or 20 year progression. As far as I guess practical first step things to keep in mind, best practices. I'm tempted to say, because my law firm sponsors for me to be here, get a lawyer. But I rarely like to say that. I mean, the real first step is figure out what you have and how it fits into the regulatory scheme, and whether you need a lawyer for that or somebody in house to figure that out is a question up to you. But you do need to know from early on how it fits into the schemes, and you can't do it stepwise. Right off the bat, you need to figure out what you have, and you need to figure out if you need to have in place compliance programs to deal with a whole multitude of different laws. And it's better to do it right up front. The SEC and the other regulators have been slow in getting started on non-fraud matters, and we can talk about how these agencies typically progress in a new area and how they develop their enforcement scheme. But it's going to happen. They're going to get into the non-fraud sort of regulatory areas, and you don't want to be caught short there. So if you figure out right off the bat what you're dealing with is something involving, say, transmission of money, which is something very, very broadly defined, and gets you in the jurisdiction of the anti-money laundering regulators, they're very specific, detailed, and highly enforced requirements you need to have there. So the first best practice is figure out what you got and make sure you have your systems set up around that. What else would you add, George?
Well, no, so I agree with everything everybody has said so far. I think with regard to am I comfortable or do I appreciate the pace with which the federal government is moving in the regulatory approach to the blockchain space? I'm surprised I'm going to say this in public, but I actually am, right? And the reason that I am is because 2 years ago, tokens were being used for one thing. Now that same token is being used for 10 different things, right? So it's like if we can't have the federal regulatory system changing every single time a new product comes into market. So it has to be stable so that companies can build systems around it. And when there is a change, that change really needs to be thought out, because it's not just affecting the new participants in the market, but the legacy participants, right? So it should be slow. And I think that's one of the things that makes our system so desirable, right? Because people, even though they'll complain about all the regulation, I think there's a lot of benefit there to the stability. The other thing too, what I would advise new companies in the space trying to save money on legal costs is, like Dan said, figure out what exactly you have and be able to articulate that in a very concise and clear way, and make sure that you're not venturing off into multiple areas, right? You really do need an attorney here, because to the extent that you're going to avail yourself to the U.S. capital markets, right? There's some rules that you got to play by. You can't just do it. There are rules that have to be enforced, and so just understand that that's just the system. Similarly, if you understand what the token you're offering is or what it is that you're trying to do, it's easier for an attorney to be able to advise you, and it'd be cheaper, right? If you come to an attorney and tell them, like, look, this is my idea, and 2 years from now, my token, so it'll be a currency now, but 2 years from now, we're actually gonna make it so that you can do X with it. Well, now I've got to analyze your legal requirements around your first proposal. Then when it changes, what does that become then? And then what happens to the initial requirements that we put in place? Everything molds. So really, you should understand what you have so that we can help you as efficiently as possible and keep the bills low.
So sort of going off that, we definitely have outside counsel, but I see there being real value in having lawyers in-house to sort of see these challenges as they come up on a daily basis, because there are a lot of challenges that come up, and it's very expensive to get on the phone with your lawyer, which we do that often, but are you going to have your outside counsel there every single move that your company is making, especially in this space where things are moving so fast? I remember on my first day, someone was like, oh, what is it, like a week here is like 6 months somewhere else, and I was like, now being there for 6 months, I was like, that's really true, and there's no way I can really briefly describe the type of issues that we're experiencing and working through. But one thing I wanted to note, going off what you said, it made me think about something Hester Peirce said, it was like a week ago or something, that this sort of ambiguity in the space, the fact that the SEC hasn't provided the sort of guidance that people might want, gives innovation room to sort of grow and I guess press those boundaries. I don't know, I sort of take a middle ground. I think regulators could do more to sort of provide that clarity without, I guess, shoeboxing the industry in, which obviously leads me to thinking about BitLicense, which I think, at one point it was, I'm sure there's some opinions about that in here, and someone asked some questions about it, but from one point of view, it was regulators acting quickly to sort of try to provide safety for New York residents. But on another note, looking at BitLicense now, a couple years later, is like they weren't fully apprised of the technology and the how complex it really is. Let's just throw BitLicense out there and see what happens. Because now in our business, we're like, okay, we have to deal with this. We're applying for BitLicense, et cetera. But some other companies, like, what if BitLicense doesn't apply? There's no definition of control in BitLicense. And that's just something that I've been thinking about lately, especially with like the model acts. Like, I've looked at those and they do have a definition of control, which I think is more, as it applies to us, it's, what the definition would be, unilateral ability to move funds or prevent funds. And from our business model, I look at that and we use 203 multi-sig. So our clearing firm has a key, we have a key, and our client has a key. So my view on that is that we can't unilaterally move our clients' funds. And I think that's where like our security comes in place. And we don't want to be able to unilaterally move client funds. So just think about that, that's something I'm thinking about on a daily, weekly basis. Also, money transmitter laws, where does that apply and where does that, not apply? We don't hold customer funds, so does, some states, we still might apply. So that's just some of the things I'm thinking about. There's cases every week, it seems like, there's also like civil litigation going on, so like how does that play into us? And, these regulators coming out with these statements, and then, I think it was like a week ago, Jay Clayton wrote a letter in response to a senator. We all thought this was going to be some of that, plain English guidance that they've been promising, but really it's just more of dancing around the issue, basically. So, that's just like a little bit of the things I'm thinking about, and I'm pretty sure other people in similar positions in the industry are also thinking about, as far as, in-house compliance. What can I do to be proactive about what might apply to us, what's happening in the industry, how are these changes going to impact the business directly, and how can I, get ahead of that so that we're best positioned to handle it. And, working with outside counsel also is just, very necessary, like you guys said.
Great, thank you. Now let's open it up to the floor. I always have more questions, but I'd like to hear more from the audience, so let's make it interactive. Anything at all, if just what?
Yeah. Go ahead. Great. Brief one to follow up on not holding the funds in unilateral. That's awesome. It seems very kind of eating your own dog food, if you will. Like, I was curious from your perspectives. Especially you two, what you're willing to say around the tech contracting terms of service. Just played around on your cookies and website. I'm curious, where are you following through on this? Like in your corporations, academia might be a little more difficult, but yeah, that's.
Anyone have the other wireless mic?
Are we sitting on it?
We'll look around.
Yeah.
Oh, here it is.
Perfect. All right. Great.
Big comfy couch.
Yeah, I'm not fully sure I understand the question about terms of service. What?
No, just in general, like, what are you doing to, I mean, everybody's caveating you're here for the same philosophy, break the mold, keep pushing this forward, you're helping your clients. So what are you doing internally or for yourselves, or, you know, as I said, like the term eating your own dog food, you know, like maybe it's a class for you that you're teaching, et cetera. Is there anything that Orrick's doing, you know, that you like to promote or anything like that internally?
Well, I identified the 4 areas that law firms generally get involved in. We're involved in all of them. We're with hopefully some fairly innovative companies involved with them, and cradle to grave service. We don't not unnecessary service, things we can live with, but things that that they all need, and we're holding their hands and getting them into the process, including. Look, we have a robust capital markets group, and we like to help introduce people to people who we think are good funders and good incubators in this area, and help them raise funds through them, and then help them make sure that their products are in gear. Again, I'm being relatively new to private practice. I'm reluctant to have somebody pay a penny more than they need to for what they need. So I want to identify what they need, what services they have, and figure out, as Stephen says, best practices up front.
So for better or worse, I have spent the past 12 years destroying the livelihoods of my students and the profession. I'll give you a couple stories. And it's been, you say eating your own dog food. Eating this dog food has been a very hard pill for me to swallow. About 9 years ago, I think, so my students and I give free legal support for innovative startup ventures. 9 years ago was the first time I saw the rumblings of what was going to happen to the legal profession. There was a company, 2 MIT engineers were launching a product called Docracy. Who's heard of Docracy? No one, okay. Docracy got bought about 3 weeks ago. Docracy is right now, I think, the largest open source, crowdsourced repository of legal documents in the world. It's built on GitHub. It allows mostly young lawyers to populate the site with contracts and take other people's contracts and annotate them and share them. It's just a very, very deep repository. And so these 2 non-lawyer engineers came to me and my students and said, can you help us build this site? And I said, let me get this straight. You want us to help you build a site that is going to destroy the chances of my students getting jobs as first-year associates at the New York firms where they will be writing contracts. And they said yes. And I said, get the hell out of school. We don't want anything to do. And then I stopped for a second. I thought, this is inevitable. And wouldn't it be better for me and my law students at Brooklyn Law School to be on the cutting edge and to be aware of what was going on? Keep your enemies close is sort of the negative way to put it. So we went into Docracy with full gusto. We populated that site more than any other lawyers in the world. And then I realized that, look, there's no doubt the legal profession is going to change, and it's going to change dramatically. And can we figure out what the tasks will be for the lawyers? No, Ray, you got something to say? What the tasks for the lawyers will be, what the tasks for the AI will be, and to make sure that our graduates are the ones that understand how they partner with automation and AI and serve the function that only the lawyers can do. And frankly, I'm convinced that the last profession that will be destroyed by automation and AI is the legal profession. And that's because we are trained to do exactly, or we're supposed to be trained in law school to do exactly what the AI will never do. The AI loves ones and zeros. The lawyer is supposed to work in the gray area, to work with ambiguity and nuance. Medical profession will be disrupted way earlier than the legal profession because we work in the gray area. So everything, so now we're holding all these automation workshops now. We're working with Community Lawyer, with Neurologic, with the other tools that will essentially get rid of the task. When I graduated from law school, I went to Big Law, and I had not an enjoyable couple of years. And I would like to think that if I was coming out of law school now, Big Law would not be a bad place for me to go now, because I would actually be using my training appropriately. I'd be learning to think and participate like a real lawyer and not taking templates and sending the templated documents out to clients. So I think it's ultimately good. Legal hackers started because of the economic downturn in the legal profession. My students could not get jobs coming out of law school, so they had to rethink how they were going to maintain a career with a law degree for the next 60 years in a world where the law firm wasn't going to embrace them for the entirety of their career. And so legal hackers emerged. We decided we're going to figure out how to think like the startups around us and help to build a profession that has that hacker startup ethos.
Here's what kills me. I'll give you a little insight into law economics. When you're doing a corporate contract, non-litigation assignment, the clients watch every penny like a hawk. And it's 12 minutes of work, you know, why did you spend the 13th minute? What did you do there? Why did I pay for a cup of coffee here? Everything. When it turns into litigation, enforcement, suddenly all bets are off. Suddenly it's hours, days, weeks of time put into defense work. I'm not saying it's unnecessary work, but suddenly it's bet the company, it's bet the house. A lot of it's insured, so that's okay too. But the transition from one to the other is remarkable, which is why the upfront work, it should be almost flipped. The upfront work, which is really protective, it's putting your systems in place to make sure your compliance is adequate, should be what's well paid and should be what's spent on. And the litigation stuff, a lot of it is just, you know, fighting and yelling at the phone and, you know, why did you ask that question? And why do you know, there's a lot of crap, but it's time consuming, and unfortunately it's a creature of legal work.
Yeah, so you're like, the economics sounds like you're engineering it to prevent legal disasters. Where did you learn about economics?
Gee, I went. It was a few years ago. Yeah.
What I'll add to that is what I think I'm doing internally myself to try to promote the space. Given that I'm not at the partner level and I can't really make that much movement, I think one of the things that's important, and I think I do it well, and Dan could attest to this, is I will talk to anybody at the firm about blockchain whenever they want to talk about it. And the beauty about blockchain is that it has so many different uses that I find myself having discussions with people from the energy group, people from capital markets, people, all these different groups, because it does apply. And the first thing that you have to get an older generation to accept is the legitimacy of the technology. Because at first, and especially during the frothy season of these ICOs and all the publicity that was out there, and the reasonable position that older partners was taking is this is just a fad. We've seen this before. This is going to die down. And the thing is, maybe the ICOs were fads, but the underlying technology is here to stay. And we need to understand that, and so I have these conversations all the time, and I'm happy to say that I think I've made a little bit of headway with it. So
I think the only thing that I want to add to that is, I mean, I haven't been in the space as long as some of the panelists up here, but even in my short time in the space, I've seen lawyers who have either stopped practicing to do something else, or been practicing but sort of just going with the status quo and not really excited about their practice anymore. But I've had lawyers who I've known who are like more excited about the law than ever, and lawyers who have gone to do something else, they're like, because of blockchain, all these, legal issues, how interesting and emerging it is, they've gone back to practicing law. So I just think that's something cool where, we have people talking about automated, taking away legal jobs, et cetera, but there are a group that are, have a renewed, I guess, just interest in their profession again. So I think that's just something really cool to see, and I'm sure I'll see more of it.
Well, fun. Let's go to Wyoming.
Hey. Hi, Kayvon Sadeghi at Schiff Harden. Thanks for the shout out a little while ago, Dan, former colleague. I guess I have a question that's sort of related to the last question, so maybe I'll start off by adding something you could mention there, which a lot of our firms are cooperating with each other and things like the Wall Street Blockchain Alliance. I think our meeting on Monday is actually at Orrick in New York, and that's a place where a lot of the lawyers are getting together and sharing knowledge in this space, which is not always the case otherwise, but we're all, sort of the view that if there's a rising tide and there's a need to cooperate and work together, which is nice to see in this space. A lot of us are advising companies on the side as well, doing things like that. I guess my question is, the SEC, the CFTC, I think, are taking a very pragmatic approach, as you talked about. They're sort of developing the law, go after low-hanging fruit, set the ground rules. If these are securities, then they can start moving up to the bigger projects that are going to be well defended. Once they already have a body of law, they're taking a very systematic approach to developing the law they want to see developed. What can the industry do on the other side of that? The industry's response seems to be very haphazard. It's, we see Kik wants to fight back, or Kraken, says they want to fight back against the New York AG, but it doesn't seem like there's a systematic industry-wide approach to developing the law on the other side. We're essentially letting the SEC roll over the industry, pick the low-hanging fruit projects, get, get law made based on cases that aren't being well defended and build the law the way they want to? What can the industry do on the other side to systematically build the law the way the industry thinks is appropriate?
Yeah, that's a great question. I'd take a crack at it, but if anybody's more eager to than I. Yeah, well, look, what Kik is doing is right, resisting. What other companies are doing to resist is just human behavior. I mean, Blockfest, caused the SEC to suffer a rare loss at the TRO's preliminary injunctions stage, even though Blockfest, nobody hears with Blockfest, right? I mean, Blockfest had terrible patent fraud, clear fraud. I mean, invented a whole regulator that they posted on their website, terrible stuff, and yet they beat the SEC there. But, we're not here to defend the people who make misrepresentations and rip people off. We're not here about that. The traditional actors, I think, should pay attention and work with the regulators about what they're doing. They are applying the law correctly, the regulators, as far as I can tell, and they are doing it. I'd echo what George said. They are doing it in a systematic way. They got caught short early on. They clearly were left behind by Bitcoin and Ethereum. And they had to back and fill and catch up. And conveniently, those tokens had, at that point, clearly were things you could define as not securities. And I think maybe it's just because we've all been pulled into the analysis now, we can all accept the fact that they're not securities, and so the lines were drawn there. But the interpretations of the Investment Company Act, of what makes something a security, of what makes somebody a broker-dealer, if the underlying product they're done with it is a security, what makes something an exchange, and exchanges is obviously where a lot of the action is. The SEC's applications of its laws seem defensible. And what I'd say is that the structures that are being created to work within those laws are structures that should be adopted uniformly, the way in which the structures were adopted in the more traditional securities world. I think that's the way to work with them, while to the extent you have a better mousetrap, to the extent you can build something new, you sit down and you talk to them. The SEC is meeting with, supposedly they're taking 3 meetings a week in their regulatory divisions to talk about new structures, to talk about approving what's going on. Take them at their word, meet with them, run something by them, try to demand an answer. They won't give you any clear answer, but I think they'll make an ugly face if they don't like what they're seeing. And I think that's the way to in sort of a Zen-like way, work with them.
Can I add one thing? So in Legal Hackers, we're very interested in the ethic of leading and then making available, workable tools for different areas of law, including regulators. One thing that comes to mind is Nina Kilbride, who's a legal hacker in the Research Triangle area, was working with us on a hackathon for people that were doing ICOs. And part of the design of that was a team that had an interesting idea where they wanted to take a path where it would not be covered by basically securities law, included a no action letter. So what would be your request for a no action letter? And that was tuned to the state securities officials. It just as easily could have been tuned to SEC. That's something to keep in mind. The other thing is, if you look at another dimension, which is commodities in the CFTC, they now have CFTC labs where they're really embracing collaborations with people to come up with new types of instruments that comply or that clearly are out of scope. So I think there are some touch points, and I like your attitude very much about how can people in the industry actually be proactive about this. So I think the answer is just do it, keep doing it. I'm actually holding the mic and I'm not supposed to be talking, so after Jonathan says something, anyone that has a question, raise your hand and I'll bring the mic to you.
So, who's read the Foundation trilogy? I think we are living in sort of the era of the Foundation trilogy where the future is almost inevitable and already written for us, and it's not good. Here's the world. If we could have planned the rollout of blockchain and crypto, we would not have done the first proof of concept be technology that disrupts financial markets. That's global financial markets. That would be the worst first proof of concept. We would have taken very rudimentary baby steps to prove the concept in very isolated circumstances and shown governments that this is viable, technology can work, and take baby steps into the major disruption of major global sectors like finance and media and governance. But that's not the world that we're stuck with, the world we got. And the problem is we're stuck in a world where bad facts make bad laws. We are not instituting the policy reform or the statutory reform or the judicial reform. Daza hit on the perfect concept. In a better world, if we could be working with government, hacking within government to show them how it can be done, and getting these sorts of no action letters or attorney general comfort letters, what have you, that is a beautiful place to be. But what we're doing is we have rewarded the worst actors in blockchain and crypto. You have to be the craziest person in order to get in the spotlight and to get your idea, which means you have to violate anyone who's abiding by the law is not going to be first to market. First to market is the one who doesn't give a damn about the law and just goes ahead with gusto. And those are the ones that are going to get the spotlight and government's going to watch, and those bad facts are going to create the bad law. We're also living in a world where everyone and his brother wants to run the policy framework for the blockchain crypto world. So what do we see? These rivalries between all these would-be trade associations, all these policy advocacy shops that pretend that they are the voice of the industry. And you've got to be loud and vocal and promote the interests of the most radicalized blockchain crypto companies in order to be the voice of the industry. And you're not necessarily doing a good job bridging the needs of the industry with the commands and of government and the broadest public policy. So if we could create sort of these new trade associations, these policy advocacy shops, blockchain for good, that's the great way to do it, I think. What? Yeah, so this is the community. Look, I always thought, I want to launch everything, and this is why I thought the global legal hackers movement is sort of perfect. It's got 140 chapters around the world, all young lawyers committed to using technology to advance the law, legal process, and the public good. That's an army. That's a global army of do-gooders that want to do this. Now, and I'm not saying it's the only one, but who's going to fund us, though, is the problem. How do you create this army when you've got all the big money supporting the most radicalized blockchain crypto ventures? And we're going to see all these fits and starts in the government. They might rule one way today. They're going to rule another way next year when the administration changes or someone else gets a new bee in their bonnet over the issues. So we cannot count on government in a vacuum to do anything good for us on this.
Yep, sorry, I'll make it really quick. The only thing I'll add to that is that the industry participants should focus on survive and stabilize and create products that people use, and at that point, I think that would give me enough time to talk to every single partner at my law firm and explain to them what blockchain is, and then I could point to successful products that are using the technology and aren't necessarily bad actors, and I use that as an anecdote, but it's just because the industry has to mature to be accepted, and for regulators to decide, okay, we need to change our rules, and because that's what's going to need to happen. Rules will need to change. So,
yeah, actually, I love Jonathan's answer. It's terrific. What George is saying. I guess what I'm saying is, you need to survive. Don't pick unnecessary fights. I mean, there's a lot of philosophy behind the blockchain, which is that we're apart from the traditional banking world, et cetera. So traditional rules don't apply to us, and that may be true in the abstract. But the government has shown its willingness to crack down, and why sacrifice yourself at the altar of your philosophy? So that's what I'd say. Find and work with lawyers or whoever else to figure out a way to compromise and bridge the gaps. But don't thumb your nose at the government, because they do have a lot of resources, and you catch them on a bad day, and they'll screw you, and it's just not worth it.
Hi, panel. Yes. I'm Monko from justcoin.com. Thank you, panel, for very insightful information. With the boom of blockchain, we put more and more information on the blockchain. And what do you think about GDPR, which is General Data Protection Regulations? Do you think this will promote use of the blockchain, and you think blockchain is compliant with the GDPR, or you Is it on the same side, opposite side? What do you think?
Fantastic question, and it's a question no one really thought about until about a year and a half ago. We were all thinking immediately, oh my God, is blockchain the great panacea for GDPR compliance? It's inevitable. The EU will say, you must put everything on the blockchain. That's the way you encrypt and secure all information. And then we scratched a little bit. Oh, I see one of the folks here who wrote a letter to the EU right in advance of the May 25th launch of the GDPR. The issue they dealt with, some of my students dealt with, was they were concerned about the logical conclusion that the blockchain technology will never be GDPR compliant because of the right to be forgotten. It's forever immutable. And should that be a reason to outlaw blockchain technology in Europe, or does Europe miss the mark? Is there an overall broader principle that says blockchain technology is probably a great way to advance and enhance privacy in Europe, but for the fact that you may not be able to comply with the right to be forgotten? So shouldn't there be some carve-out, some exception to recognize the overall advantages of blockchain in a privacy-sanctifying world, and then figure out whether or not there are workarounds on the right to be forgotten issue there? So that was sort of the third rail issue for us. Is it dead in the water because it can't satisfy the right to be forgotten?
So I mean, just a quick answer to that. My first assignment at LGO was actually I created GDPR policy, and so I had to basically learn about what this is and how it could impact this business that I just joined, and then really just trying to learn about. But anyways, that's something that complying with AML and KYC obligations, we have to sort of ask our vendors, okay, so we're giving you this information, like our client's passport, ID, etc. How are we going to be sure that once we release that to you, that that you're erasing it within 14 days, like you're telling us we are? So that's been something that we've thought about. And then from the blockchain aspect, I'm probably not best at describing it, but how we do it, we have a centralized order book where it's centralized for efficiency reasons, and then on chain, after orders are matched, we have the transactions batched and put on the Bitcoin blockchain. So that has no PII. So we think that's compliant and that there's no customer information that's saved in this immutable, sort of way. So, 2 cents.
I do know our journal received a submission recently that addresses the French government's kind of response to this situation, right, where there might be not so much coherence between blockchain and GDPR, and I'm happy to say that there is some kind of some sandboxing. Depends on the jurisdiction, but there are efforts to kind of address this issue because enough people realize that there is some incompatibility. So it's not like people are sticking their heads in the sand. It is being worked on. Coming from an antitrust background, I was a lawyer for about 4 or 5 years at James Day. One thing's for sure, it behooves a lot of national governments to really work on these issues because, again, no one wants to be left behind. So I think there are enough kind of voices of reason hopefully embedded in different agencies of different national governments to understand that it's something they need to work on with hopefully some polycentric cooperation. By that I mean, not just consulting government people, but also civil society, startups, practitioners, so forth. I think it's pretty much become more of an accepted model rather than just calling the shots from above. So hopefully we see more of that.
Thank you so much for your time. I'm Christopher. I'm a student at the Brooklyn Law School. I'm a practitioner from Trinidad and Tobago. And it's recently been announced that the Eastern Caribbean Central Bank is launching a blockchain-based currency. And so I'm seeing an international recognition of the power of the platform going forward. And what's really interesting to me is that technocrats are taking it to the point where they're willing to make themselves petri dishes. And I was wondering whether you think that it is possible within the states that maybe a state would take on the position of being that petri dish to see different ways in which administrative procedures could be used to implement and enhance American uses of the blockchain technology.
So, perfect question. The problem is the supremacy clause of the U.S. Constitution and the nature of internet communications because they traverse interstate boundaries. Wyoming is trying. I asked earlier who was aware of what was going on. Wyoming is trying to create an intrastate Petri dish. And at last year's Computational Law and Blockchain Festival, a bunch of the students and participants tried to create a mechanism by which they could allow for Wyoming to become that Petri dish. At least that was one of the approaches. The thought was, can you create a, so Wyoming has essentially said, it's a haven for crypto transactions, period. The problem is, if they can keep it in the state, it could be fine. It might not invoke any supremacy clause issues, any federalism issues. But the problem is, how do you allow everyone else who wants to participate in the market to be actual participants within Wyoming itself? So the thinking we had was, can we create, anyone who wants to participate, set up an LLC within Wyoming? So you could be a New York resident, but you run an LLC in Wyoming. And when you buy the crypto within Wyoming or participate in the blockchain activity within Wyoming, it's strictly within the state of Wyoming. If that became viable, the problem was the economics didn't quite work out.
Well, I mean, just as a matter of rejoinder, I think taking an example or idea to a further extent, it could be possible that Wyoming could pass legislation to not only to make a derivation of a legal personality that strictly for this purpose, where participants can register under this personality and therefore become Wyoming residents for this purpose, for a non-economic purpose, and they'll only pay taxes on their, let's call it blockchain transactions or whatever.
So I love it. So yeah, Wyoming, I think it costs $99 to become an LLC in Wyoming, and I think you could become a series LLC in Wyoming, which means, and Brendan might know more about this. You could become so that every time you wanted to participate, you create this new LLC, but it's still that $99 threshold. Could you create this micro entity for $1, say? That would be an interesting approach for Wyoming. And I don't know, has anyone been exploring what's been going on in Wyoming or the other states in this regard? Yeah. Okay. Anything more? Did I miss a nuance that Wyoming has been exploring more recently? And if folks know about other states, that's great.
Great, thanks. I think fundamentally the important thing to think about in this space is goes back to use, right? What are these things used for? Are they securities? Are they not securities? Are they property? If it's property, states have jurisdiction, right? What if it's something fundamentally different? Like the missing part of the machine. I mean, fundamentally, blockchains are about identity, right? So that doesn't fall under the jurisdiction of any of these financial institutions. And the fact of the matter is that you can take anything and you can run a process on that. You can make it a hash of that and put that on a blockchain. So what is it now? We have to think about these things as their use and their representation.
Can I make a comment? On GDPR, GDPR is not just right to be forgotten. If you look down to Article 15, people have a right to get a copy of their personal data. How about an Oracle or an integration that makes it simple to get all of your transactions or all the references if it's more like a data file? Another great one is the algorithmic decision-making section. So with DAOs and smart contracts, they would qualify as algorithmic, and if there's some sort of decision that affects your legal rights, like, is my loan approved or not, there's a requirement under GDPR that the people operating the system be able to explain the algorithm and how it achieved those results. I think there's a lot in the GDPR that's very, very friendly to and suggests a good direction of innovation for people that are interested in blockchain and other innovative technologies for the law. Do we have time for one more question, Steve, before we... I think
one more?
Okay.
Break for lunch.
Sir.
So if any of you have a dream no action letter that you think you could reasonably get the SEC to grant no action relief on, what would it be?
Wow. I'd like to get the SEC to give more guidance through a no action relief as to when an entity or a blockchain has become sufficiently decentralized so that it's no longer a security. I think that would help a lot of companies that issued their tokens or entered into a SAFT, right? And now they're waiting to issue the tokens to their SAFT participants. And if they want to use that argument, it'd be great to get the SEC's kind of detailed analysis on at least another use case other than Ethereum where they've seen that happen.
Yeah, I agree. That's something that, I'd be interested in having them, talk more about. There's a podcast I was listening to the other day where they were talking about how, the SEC is sort of like so far set up decentralization as a standard for, thinking about securities laws. And, it's decentralization is sort of vague. How many nodes, how many holders do you need? So that's something the SEC I would like to hear more about. Also, I guess then my answer would be, something about custody or control. Like I'd ask them, is this in our situation at LGO Markets where we have multi-sig, we have control spread across parties? I mean, I don't know. How does that fall,
Yeah, I was going to echo the latter. There's so many sort of regulated type entities under the securities and commodities laws, and that if an entity is not involved in real custody, can you have a lighter regime of regulation that doesn't incorporate the full 34 Act requirements?
Yeah, like some sort of risk base. Okay, you're only holding one key to the asset. How can regulations sort of view that through like a risk-based lens? Exactly.
That's a great question. Yeah.
So I wouldn't trust I wouldn't trust a no action letter from the SEC. It's not worth the paper it's printed on because it will have, at least on substance. As a substantive matter, it won't last beyond the administration or the next review. What I would trust the SEC maybe is to do something on limited process reform. So could they create some sort of rocket docket, an expedited procedure where you can actually make a request of the SEC? It may last for a short duration, but at least you can ask them a specific question and they'll come up with a quick answer. So they've done, the federal government's done that in other contexts, rocket dockets for patent relief kind of issues. Could they do a rocket docket for a crypto blockchain question process? That might make sense.
Right. Okay, thank you. Thanks to our, have a round of applause for our awesome panelists. For the audience as well.